Hi, my name is Emma Austin and I'm the Head of Health and Social Care Law at Central England Law Centre. This webinar is on social care during the pandemic and specifically on the changes to social care law for adults. The webinar is designed for those working in the welfare rights sector, charities, disability organisations, advocates, community activists and carers. During the webinar, we're going to have a look at the pre-existing social care law before the pandemic, which is contained in the Care Act of 2014. We're going to look at changes to social care law introduced by the Coronavirus Act 2020 and in particular Care Act easements. We're going to have a look at what hasn't changed and what the changes mean for service users and their carers. And finally, we're going to consider what can be done on behalf of service users, carers, vulnerable individuals if there's a dispute about the support that they need and the support that they're receiving. I do hope this proves useful to you, your organisations and to those that you work with. I think it's safe to say that the pandemic has changed the way that we think about social care in this country. There certainly seems to have been a greater awareness amongst the general public about those who need health and social care services, and also a much greater acknowledgement of those who provide care. Carers have been heralded as the heroes of the pandemic and have been applauded on a weekly basis. But that goes with a situation where we're seeing a greater demand for social care services as a result of people becoming ill or people's needs changing due to measures introduced to curb transmission of the virus. Additionally, those who are already receiving health and social care services have in many instances found that their care provision has changed as a result of social isolation, shielding, or inability of services to remain open, for example, day centres and respite facilities due to social distancing measures. And in response to the pandemic, something very significant has happened legally in that the Care Act of 2014 has been amended. So adult social care law, as it was before, has changed in response to the changing social care climate that we've seen. New law has been introduced through the Coronavirus Act 2020, and there is a lot of accompanying guidance to that act, which also sets out how the local authorities should be operating and providing support to vulnerable individuals during the period of the crisis. We're going to start by looking at adult social care law before the pandemic, and in particular the key provisions of the Care Act. The reason for that is that, as I'll go on to explain in more detail later, for much of the period of the pandemic, the correct law will still be the Care Act, and it's the Care Act that we'll need to look to in order to understand what duties councils have or what rights individuals and their carers have. It's only in certain circumstances that some of the changes introduced by the new measures will begin to operate. It's really important that we have a good understanding of the Care Act provisions in order to understand how individuals and their carers should be treated. The Care Act sets out the key legal duties and powers that councils have towards adults and their carers. And by adults here, we mean those with health conditions, disabilities, illnesses, those who might need some help or care and support to manage personal care, other activities of daily living, accessing the community, those who might need help to manage some aspect of their daily lives. The key duties and powers that councils have towards them include duties to assess their needs, decide what support might be required to meet needs. Councils have duties to develop support plans for individuals who may require help, to provide support or care to actually meet any needs that have been identified. Councils also have a general duty under the Care Act to promote wellbeing. They have a duty to prevent needs for care and support from arising. They have duties to provide information and advice about services in the area and about care and support that individuals might be able to access. And councils have duties to safeguard vulnerable adults under the Care Act. We're going to break down those key duties now that councils have, and we'll start with the first very significant duty, which is the duty to assess. And assessment under the Care Act is the process where councils establish whether individuals have needs, and if so, what those needs are, and whether particular help is required to meet those needs. The Care Act includes provision for assessment of both adults and also their carers. The duty to assess adults arises where it appears to a council that an adult may have a need for care and support. Not necessarily that they will have a need for care and support, but simply that they may do, so the threshold is quite low. For carers, the duty of councils to assess arises where they may have needs for support, and whether those needs are now immediate or in the future. So it may be that a carer's situation would break down if support was not provided in those circumstances. An assessment should be conducted. The Care Act itself and important guidance to the Care Act set out precisely how assessments should be carried out. It's clear from the Care Act guidance that assessments should be conducted in a proportionate manner to the needs and circumstances that arise. The more extensive and complex an individual's health situation or needs are, the more in-depth an assessment will need to be to properly analyse what support might be required. The Care Act makes clear that assessments should be carried out in a way that enables participation of the individual it concerns, and it should also include those that the adult or their carer want to be involved. For example, sometimes there are health practitioners or individuals who work with that adult in a day centre care home setting who might have particular knowledge or insight into that individual, and if the adult or carer wants them to be involved in the assessment process, then the Care Act guidance and the Care Act itself make clear that that should happen. Assessments should consider the impact of an individual's circumstances on their well-being and particular outcomes that they want to achieve with their life. The assessment should also look at whether there is anything other than the provision of care and support that might help an individual achieve those outcomes. For example, sometimes provision of information and advice might in itself be sufficient to resolve certain outcomes that an individual wants to achieve. It's clear from the Care Act guidance that assessments under the Care Act consider all care and support needs, regardless of whether support is already in place to meet those needs. So the assessment itself looks at what the entirety of an individual's needs are, rather than simply those needs that are currently unmet. That means that for the purposes of an assessment of a vulnerable adult, any informal or care or support provided by family or friends should be ignored. It's the need that is the focus of the assessment. In addition to looking at well-being outcomes that a carer seeks to achieve, in a carer's assessment, the council also needs to look at whether a carer is willing and able to provide the care that they're providing, whether now or in the future, whether the carer wishes to work or does work, and the impact of their caring role on that, and whether a carer is participating in or wishes to participate in education, training, recreation. In other words, the impact of the caring on the carer's own life and their own ability to carry out the things that they would like to do. Councils have a duty at the end of an assessment process, either of an adult or a carer, to provide that individual with a copy of the assessment that's been undertaken. Following an assessment, a council has a legal duty to actually make a decision about what an individual's needs are and whether support is required to meet those needs. The decision about what an individual's needs are and whether they are at the point where support will be required is made in line with the national eligibility criteria. And essentially those are a set of standards of levels of different needs. And if an individual has needs which fall into a certain level or category which is set out in the national eligibility criteria, then a council will have a duty to provide them with support to meet those needs. And the reason that all councils now have needs set at the same level is to allow portability of care if service users move. So service users will then know that they can access support in a different area if they were to move home, because their needs would be considered to be at the same level. For adults, the national eligibility criteria state that adults are eligible for support where their needs arise from or are related to a physical or mental impairment or illness. And as a result of those needs, the individual is unable to achieve two or more of the outcomes that we'll go on to talk about in just a moment. And that as a consequence of this, they are or they're likely to have a significant impact on their well-being. The outcomes that are mentioned in the Care Act and in the eligibility criteria are managing and maintaining nutrition, maintaining personal hygiene, managing toileting needs, being appropriately clothed, being able to make use of their home safely, maintaining a habitable home environment, in other words, keeping it clean and appropriate to live in, developing and maintaining family and other personal relationships, accessing or engaging in work, training, educational volunteering, making use of necessary facilities or services in the community, which include public transport, recreational facilities or other services, and carrying out any caring responsibility that the individual might have for a child. Individuals are considered to be unable to achieve those outcomes where they can't do it without assistance, or doing it without assistance would cause the adult significant pain, distress or anxiety, or doing the activity without assistance would endanger the health and safety of the adult themselves or others, or where they could undertake the activity without assistance, but if they did, it would take significantly longer than would normally be expected. Councils take a decision that carers are eligible for support where their needs arise as a consequence of providing necessary care to an adult, and the effect on the carer's needs is that the carer's physical or mental health is at risk of deteriorating, or the carer becomes unable to achieve certain outcomes, and as a consequence there's a significant impact on the carer's well-being. The outcomes that are relevant to a carer are that they may become unable to carry out caring responsibilities for a child, or they might have caring responsibilities to other persons that they may be unable to achieve. Maintaining a habitable home environment in their own home, managing or maintaining their own nutrition, developing or maintaining their family or other personal relationships, engaging in work, education, training, volunteering, making use of facilities in the local community, which include recreational facilities and services, and engaging in recreational facilities and activities. A carer is considered unable to achieve those outcomes where they can't do so without assistance, or doing so without assistance would cause the carer pain, distress, anxiety, or doing so without assistance might endanger the health and safety of the carer or others, and that could include the adult for whom they're providing care. Where councils make a decision that individuals have eligible needs following an assessment, the council has a duty to meet those needs, and similarly, if a council reaches a decision that a carer has eligible needs, then the council must meet those needs. Councils also have discretionary powers to meet needs that they've identified during the course of an assessment of either an adult or a carer that don't meet those criteria, those eligibility criteria that we've just discussed. So they have a duty to meet those needs that are eligible, and they have a power to meet other needs that they recognise during the course of an assessment. Another key duty that comes from the Care Act is the duty of councils to produce support plans after they have completed an assessment and made a decision about an individual's needs and whether any help is going to be required to meet those needs. And the duty is that councils must produce a care and support plan which sets out what needs have been identified through the assessment, whether those needs meet the eligibility criteria or whether they're non-eligible needs, whether the council intends to meet those needs, and if so, how, what outcomes will be met through the provision of support, i.e. is the support designed to enable an individual to maintain their nutrition or manage their toileting or access recreational facilities or services in the community. The support plan should include details of the personal budget, that is to say, the amount of money that the council considers is going to be needed to procure support to meet the needs identified therein. The support plan should include details of information and advice on reducing needs and preventing and delaying the development of future needs. And additionally, in carers' support plans, the plan itself should also set out the views and wishes that the carer has about providing care and about their views and wishes as to themselves engaging in work, education, recreation. The care and support plan must, under the Care Act, be kept under regular review. The next significant duty that councils have under the Care Act is to actually provide support to meet eligible needs that they've identified. And needs can be met in a lot of different ways under the Care Act, and there are certain types of support that are listed, but this certainly isn't an exhaustive list, and the idea is that support is tailored and bespoke to meet the particular needs that an individual or their carer have. The types of support that could be provided by the council to meet needs would be accommodation in a care home or in premises of a similar type, for example, supported accommodation. It could include provision of care and support at home or in the community. It could include counselling. It could include provision of goods, equipment, facilities, certain undertaking adaptations or providing certain equipment to assist an individual with a disability to manage an activity of daily living. And it could include access to information, advice, provision of an advocate to manage certain situations. Councils can either provide those services directly under the Care Act, or they can arrange for somebody else to do that, either by procuring that care from an agency or paying the individual who needs that care and support by way of what we call a direct payment to then procure the care themselves. So they'll give the money to the individual who then will use that money for the purposes of paying for the care and support services that they need. In addition to these very specific duties around assessment, decision making, support planning and provision of care under the Care Act, councils also have very important general duties, and the first of these is a duty to promote the well-being of individuals, and that word can include both adults and their carers. Well-being includes lots of different aspects of an individual's life. It includes personal dignity, physical and mental health, emotional well-being. It includes protection from abuse and neglect, exercise of control by an individual over their day-to-day life, ability to participate in work, education, training or recreation. It includes social and economic well-being. It includes domestic, family, personal relationships and suitability of living accommodation. Well-being also includes the ability of an individual to contribute to society. And the Care Act and the guidance make absolutely clear that there is no hierarchy to these different aspects of well-being. That means an individual's ability to exercise control over their day-to-day life, i.e. to make choices, an individual's contribution to society is as important as preventing them from being subjected to abuse and neglect, it's as important to aspects of their physical dignity. And this is really important and really groundbreaking within the Care Act, because previously often some needs were considered to be much more significant than others. So an individual's toileting needs were considered to be much more important than an individual's needs to socialise with other humans and be part of their community, for example. Well, the wellbeing principle in the Care Act makes clear that an individual is a whole, and that all of these different things contribute to an individual being well and being able to function in the way that individuals should. To actually promote wellbeing, councils need to recognise a number of things. That individuals are often best placed to judge their own wellbeing, so they might be able to know what's best for them better than a social worker or assessor who's coming in who doesn't have a relationship with them previously and doesn't have the same knowledge that an individual does about their own life to know what's going to work for them and what things are particularly important to them. Considering well-being involves taking an individual's views, wishes, feelings and beliefs into account in conducting assessments, in doing support planning, in making decisions about services that need to be provided in the area. Well-being includes consideration of preventing, delaying and reducing needs for care and support. It includes considering relevant circumstances to that individual and ignoring irrelevant circumstances, so to avoid making assumptions about an individual simply based on their age, appearance, medical condition. Wellbeing involves trying to maximise an individual's participation in the process of assessment, support planning, decision making, and procuring support services, but also in society more generally. Wellbeing, it's clear from the Care Act, also involves a careful balance between looking at the wellbeing of an adult and the wellbeing of their carers, and not to promote one at the expense of the other. Wellbeing includes considering protection from abuse and neglect of vulnerable individuals, and includes considering what is the minimum restriction that should be imposed on individuals' rights and freedoms in order to look after them and to keep them safe and allow them to be part of society. The duty of councils to promote wellbeing applies at every level of a council's functions in respect of social care. That means that it applies to individual assessment, decision-making, support planning of adults and of carers, but also to local authorities in their duties when they are commissioning services in an area. Councils also have another important general duty, which is the duty to prevent a need for care and support arising, and they have to provide and arrange for the provision of services, facilities, resources in the area in order to do this. This is a duty that councils have towards adults and their carers, and in order to do that, councils have to identify what services, facilities, resources they have in the area, identify what adults they have with unmet care and support needs, and identify what carers they have with unmet support needs, and then marry those things up. So look at whether unmet needs could be met through the provision of services, facilities and resources. Under the Care Act, councils have an important duty, which is providing information and advice to enable individuals to understand what care and support is available in their area and how social care provision works in their particular area. This includes councils providing information about choices available in terms of different kinds of accommodation, types of care, ways that support plans can be managed, etc. How to access care. So how does an individual who needs help in the first place go about getting that help? Information about accessing financial advice, if it's an individual who has financial resources and has to consider contributions for care costs, for example, and information and advice services in the area needs to include information about how safeguarding concerns can be raised on behalf of vulnerable individuals. And that leads to the final key duty of councils that I'm going to talk about under the Care Act, and that is the duty of councils to safeguard vulnerable individuals, vulnerable adults. And for adults, that safeguarding duty arises where councils have reasonable cause to suspect an adult who has needs for care and support, whether or not the council is actually meeting those needs, is experiencing or is at risk of experiencing abuse and neglect. And as a result of their needs, that adult is unable to protect themselves against that abuse or neglect. And councils under the Care Act have to conduct inquiries that they consider necessary to determine what action should be taken. So councils have to undertake a proportionate inquiry in order to respond to the circumstances of an individual situation. Abuse, for the purposes of this safeguarding duty, includes the traditional forms of abuse that we think of, for example, neglect, physical abuse, sexual abuse, but also explicitly includes financial abuse. Now we've had a look at the key provisions that existed before the pandemic in adult social care law. We're going to have a look at the changes to social care law that have been introduced now. And these have been introduced by the Coronavirus Act of 2020. The Coronavirus Act introduces a significant number of legal changes across a number of fields of law. We're going to focus on those that affect adult social care law, particularly changes to the Care Act. The measures introduced in adult social care law were introduced by the government because it was anticipated that during the pandemic, councils may become unable to fulfil their Care Act duties if their staff numbers were significantly depleted due to illness or self-isolation, for example, or the demand for support in an area increased to such an extent that the council simply didn't have capacity to respond to the need that was out there. The emergency measures allow for departure from key Care Act duties, and a number of the duties in the Act are modified or suspended by the provisions of the Coronavirus Act. These modifications and suspensions of Care Act duties are called Care Act easements, and that term is a term that comes from the guidance rather than from the Coronavirus Act itself. But it's the term that we will use as it's the term that's been commonly adopted. It's important to understand that those departures from Care Act duties, the Care Act easements, affect not only those who are already receiving social care support from councils, but also those to whom duties may have arisen before the Coronavirus Act was introduced, but who hadn't yet started to access support. So that might, for example, include people who had asked the local authority to conduct an assessment, but that assessment may not have been completed as yet. The provisions also will affect those who might need care and support for the first time, so people who weren't in any way involved with the council social services before the pandemic arose. The measures in the Coronavirus Act affecting adult social care are due to be in force for the next 2 years. So they came into force at the end of March of 2020, but they're due to continue for 2 years. That period can be lengthened or shortened as the pandemic develops, depending on how things unfold. And after that, the Care Act is due to be reinstated in full. The key provisions affecting adult social care law are contained in section 15 of the Coronavirus Act 2020 and detail setting out the particular parts of the Care Act that the easements apply to is provided in Schedule 12 of the Coronavirus Act. There's also a significant volume of information contained in guidance that's been issued by the Department for Health and Social Care, also by Her Majesty's Government, the NHS and Public Health England. In particular, the Care Act easements guidance for local authorities sets out how it's intended for councils to operate easements in practice, and the ethical framework for adult social care guidance underpins how decision making at a high level within councils and at an operational level by social care practitioners should be made. So those are particularly important pieces of guidance here. The other sets of guidance provide useful information for particular types of care in certain settings or particular ways of care being provided. For example, there's guidance on hospital discharge, there's guidance on domiciliary care or home care support, there's particular guidance on direct payments. The Coronavirus Act allows for departure from key Care Act duties. We need to look now at which duties the councils are able to depart from through exercising Care Act easements. The first key duty is the duty of assessment. The duty of councils to assess the needs of both adults and carers have been removed. The duty of councils to produce written records of assessments has been removed, and also the assessment and notification duties that councils have to other councils when a service user moves from one local authority area to another have been removed. All of these duties have been replaced with a power, which means that councils can undertake these assessments, provide that notification, produce a written record, but they don't have to. Council's duties to make a decision about the level of needs individuals have and their eligibility for support are removed. And these duties are similarly replaced with a power. The duty of councils under the Care Act to prepare care and support plans following an assessment and a decision about eligibility for support have been removed. Similarly, the duty of councils to review care and support plans regularly has been removed, and these duties have been replaced with powers. And finally, the duty of councils to provide care and support to actually meet eligible needs have also changed. So now these duties arise where an adult is resident in the area, or if they have no settled residence, where they're present in the area, and support is necessary to avoid a breach of their human rights. And then there's certain rules around whether charges have been imposed or not, and they can't be unless certain conditions are met. But essentially the duty to provide care and support now arises where it's necessary to avoid a breach of human rights. So that's a very significant raising of the threshold to be a point at which local authorities have a duty to provide care and support. Otherwise, if that high threshold is not met, councils have a power to provide support to meet needs instead. Similarly, the duty under the Care Act for councils to provide support to meet the eligible needs of carers has changed. And again, the duty now only arises where support is necessary to avoid a breach of human rights. Otherwise, councils simply have a power to meet the eligible needs of carers. Other Care Act duties which easements apply to, I'll touch on very briefly, include the duty that councils have ordinarily to carry out financial assessments to look at whether and how much individual service users should contribute towards the cost of their care. That duty has been removed, though it's important to say councils can't charge for care that they provide unless a financial assessment is done. However, with easements operating, councils can apply charges retrospectively to care that they have been providing during the period of the pandemic after they've caught up with themselves and done a financial assessment. So it's important that service users are aware of that. The duty to do a financial assessment is, however, replaced with a simple power of local authorities to do that financial assessment. Another duty that has changed is that the duty of councils to give effect to adults' choices of preferred accommodation if they need to go into residential care have been removed, and instead councils have a power to give effect to adults' choices of accommodation rather than a duty to do so. And finally, another key duty that's changed is the duty councils have relating to hospital discharge processes. The discharge processes of patients has changed quite significantly for NHS practitioners during the pandemic, and corresponding duties of local authorities have similarly been modified. So it's important if you're working with individuals in that area that you're aware of those changes. So we've seen that Care Act easements represent a very significant departure from key Care Act duties that we've talked about, but they don't apply all the time. So although Section 15 of the Coronavirus Act, which introduces Care Act easements, is now in force, the easement guidance that's been issued by the government states that easements should only be used by a council when the council take the decision that their workforce is significantly depleted or the demand on social care has increased to such an extent that it is no longer reasonably practicable for that council to comply with its Care Act duties as they stood prior to the Coronavirus Act, and where if they carried on trying to comply with those Care Act duties, it would be likely to result in urgent or acute needs in the area not being met, potentially risking life. Any change resulting from such a decision should be proportionate to the circumstances in a particular local authority area. Now that's really important because the easement guidance is setting a very high threshold for the introduction of easements in a council area, i.e. that councils should only be starting to depart from their Care Act duties where it's no longer practicable for them to continue to comply with them, and if they were to try and do that, they would risk not meeting urgent and acute needs, or they would be risking the life of individuals in the area. This suggests that easements are a sort of last resort measure. They're an emergency measure to be used by councils. They're not to be used as standard during the period of the pandemic. And in fact, the easement guidance goes on to say that councils should do everything they can to continue to meet Care Act duties before using easements. So this means that the previous law, i.e. all those Care Act duties that we have discussed in the first part of this webinar, apply, and councils should continue to comply with those duties to assess needs, make decisions about support needs and eligibility, prepare support plans and provide actual care and support to meet needs under the Care Act, unless it's simply not feasible for them to continue to do so. Where departure from Care Act duties is considered necessary by councils, so where they do reach that high threshold, the guidance makes it absolutely clear that the easements that they introduce should be time limited. They should be used as narrowly as possible. So this doesn't create a carte blanche for local authorities to depart from all of their duties if it's simply one area or one function that they would have difficulty in performing during the period of the crisis. The Care Act easements, if they are introduced, must be reviewed very regularly, and the councils are under an obligation to revert to full operation of the Care Act as soon as possible. How then do easements work? So if the local authority does reach that threshold, how do they actually operate? Well, the guidance sets out 4 levels of easements, and each level represents a more marked departure from Care Act duties than the last. They're referred to in the guidance as stages of easements, but I think the language is slightly misleading because these stages, these levels, aren't necessarily sequential, so it's possible to move from level 1 to level 4 without going through levels 2 and 3, for example. The level of easement applied by a council depends on the capacity of that council to respond to the particular demands in their area with the workforce that they've got, i.e. easements should be a proportionate response to the situation that's unfolding in a particular council area. The 4 levels of easement set out in the Coronavirus Act are as follows. In the first stage or level of easement, Care Act duties are actually complied with in full. Everything is operating as usual. So this isn't really an easement at all. But it is the first level that's identified in the Act. The second level enables councils to apply some flexibility to change or defer services that they can't deliver because of social distancing, isolation measures, for example. It doesn't mark a significant departure from Care Act duties, but rather the way Care Act duties are carried out might be slightly different. So, for example, assessments might need to take place on the telephone or with a self-supported questionnaire rather than face-to-face interaction with the social worker. Equally, there are certain services, for example, attending day centres, that might not be possible in the present time due to social distancing measures. And in those circumstances, the local authority, if applying this level of easement, level 2, should be providing support in a different way to meet the needs that would ordinarily be met through attendance at a day centre. So Care Act duties are complied with, but just in a slightly different way. The third level of easement is where easements really start to bite, and there is a much more significant departure from Care Act duties by the council. And this stage is entered into when councils consider it's untenable to continue to comply with their Care Act duties, so they cease to carry out certain functions in the manner that the Care Act prescribes, and instead they streamline their processes. So this enables councils to start stripping away what they're going to do and what they're not going to do on a much more widespread basis. The idea is that this enables councils to respond in a proportionate way to undertaking assessments, making decisions, support planning, and providing support in a way that enables them to carry on helping as many people as possible, or those with the greatest needs, but allows them to sort of drop duties that at the time they don't have capacity to perform. And the final stage of easements is the most significant departure from the Care Act. And that's an approach where councils decide that they need to start prioritising care and support certain services or certain types of need, and those are the ones they're going to focus support on, and that might mean other needs across the area go unmet. This could lead to removal or reduction of support from existing support packages. It could lead to some service users not having amendments to their support where those amendments might be needed, or new service users might not be getting support, which if they were assessed under the Care Act, they may well be entitled to. So this is a real change in the way councils practice. The decisions of councils as to which level of easement they're going to be applying at any one time during the pandemic is clearly very important, a very important decision, given the difference between easements at level 1, where everything's operating as usual, and at level 4, where they're going to be prioritising certain services or types of needs and not delivering support to meet all of the needs that they might have in the area, or all of the kinds of services that they would normally provide. The decisions can't be made lightly or on an ad hoc basis as to which level of easements are going to be applied, but rather there is a formal decision made by high-level figures in the council, and I'll go on to explain who those are in just a moment, to move to a specific level of easement. So high-level figures make the decision to move to a certain kind of easement, and then individual social work practitioners have to apply that level of easement to their day-to-day caseload, which means they make decisions in individual cases as to what support an individual might be entitled to based on which level of easement is operating. The decisions taken by the council about which level of easement should be operating must be proportionate to the circumstances in the area at the time. So councils shouldn't be going beyond what is necessary and should be endeavouring to meet their Care Act duties wherever possible. Unsurprisingly, given that each level of easement signifies a more marked departure from the Care Act duties than the last, the guidance sets out processes that need to be followed by councils in reaching a decision to move into different higher levels of easement. And the guidance sets out that certain figures need to be involved in decision making, certain figures need to be making the decisions in consultation with others, and that in some cases the government needs to be notified of those decisions. So let's break those down for the different levels of easement. There isn't anything specific in the guidance about operation of stage 1 or level 1 easements where everything is operating as usual, but that's perhaps unsurprising because everything in a council area should be delivered in the same way that it ordinarily would be under that level of easement. For stage 2, the guidance sets out that if it's needed for councils to start delivering services in a different way or providing care in a more flexible way, the service manager of a particular type of service should consult with the principal social worker and set out reasons why they consider that service can't be delivered in the present time, what the impact on service users and carers would be of removal or that service being provided in a different way, and alternatives that those individuals might have to care. The principal social worker, if persuaded that that service type is undeliverable, will refer to the Director of Adult Social Services, who will make a decision about whether to stage 2 is then going to be operated. At stage 3 easements, the Assistant Director or Senior Manager must consult with the Principal Social Worker, again setting out the reasons why they think a departure from the Care Act is necessary, in this case to streamline processes, what the impact on service users and carers would be. And if satisfied, the Principal Social Worker must make a recommendation to the Senior Management Board for a decision. And that decision should involve discussion with the local NHS leadership, and the principal social worker and the Director of Adult Social Services also need to involve and brief the lead member of the council, i.e. the portfolio holder for adult social care, in their decision making. If a decision is then taken by the Senior Management Board to apply streamlining to their delivery of social care, i.e. to move into this third level of easement, and the Department of Social Care must be notified. Finally, the fourth stage of easements, that highest level and most marked departure from the Care Act, involves a process where the Assistant Director or Senior Manager within the Council must consult with the Principal Social Worker, again setting out the reasons why the decision's been taken, impact on service users and carers, alternative sources of care. The Principal Social Worker then needs to call an emergency decision meeting with the Director of Adult Social Services about whether it really is necessary to move into this fourth level of easement, the prioritisation of certain types of service or need, and if so, how they're going to prioritise care. The Director of Adult Social Services and the Principal Social Worker again should be involving and briefing the lead member of the Council in their decision making. And again, the Department for Health and Social Care must be notified. In making decisions about entering a certain level of easement, or in making decisions on a case-by-case basis about how the easement should operate in relation to an individual accessing care and support, the practitioners in the council, so the high-level decision makers and practitioners, need to do a number of things. So first, it's probably an obvious thing to say, but they need to comply with the law and the guidance, so they need to act lawfully. Secondly, they need to comply with wider, broader public law principles which require public authorities to act rationally and fairly in the exercise of their public functions. Delivery of social care is a public function that the council has, and therefore in delivering social care, making decisions about how to provide care and support to individuals, or how to ensure that the whole area has a workable system of adult social care in relation to those high-level decisions, the council must act fairly and rationally. The decision makers within the council, both at high level and also on a case basis, so individual social work practitioners, also need to be by principles set out in the framework, which is new guidance that's been issued that we'll talk in just a moment. And the decision makers also need to remind by the Coronavirus Act itself and the easement guidance, avoid breaching human rights. So they must not leave individuals in a position where without support would be a their human rights. We'll look at the first of those aspects of the way in which decision makers and council executives seek to provide social care. The first of those is lawfulness. So I said that they need to comply with the law and the guidance. Here, the correct law would be the Coronavirus Act and the guidance, including the easement guidance, the ethical framework guidance, any other relevant guidance relating to the specific service type or way in which support can be provided that's been issued. But, of course, much of the time during the pandemic, as we've discussed, the correct law will be the Care Act, because where low levels of easement are operating, i.e. level 1, where everything's operating as normal, or level 2, where there's simply flexibility in the way that Care Act duties are exercised, the correct law will be the Care Act. So we need to go back to and understand those principles set out in the Care Act provisions about the local authority's duties towards individuals and the rights that individual adults and carers have in respect of accessing care and support. Councils have said also need to act rationally and fairly. Well, what does that mean? Well, the duty that councils, public bodies have to act rationally means that in the actions and decisions they take, they must do what is reasonable. By reasonable here, we're actually applying quite a high sort of threshold to the term. It's not the word as we would ordinarily understand it in English language. What we mean is the council is making decisions that aren't so unreasonable that no other reasonable authority would do the same in the same set of situations. So we think there about, is what they're doing a proportionate response to what is happening, what's unfolding in their particular area, based on the evidence and the information that they have. The duty to act fairly requires that if there's particular procedures set out in the legislation, in the law itself or the guidance, that those are followed, but also more broadly that public bodies act fairly. And that means that the council should be adopting fair procedures, applying fair policies and practices. So if they choose to enter level 4 easements, for example, that they apply their prioritisation principles equally and fairly to all. If an individual falls within a certain set of criteria that they develop, an individual should expect in those circumstances to be able to access support in the same way as another individual with an equivalent need. I mentioned that both high-level decision makers and social work practitioners making decisions on a case-by-case basis about what individuals might require in terms of support are bound by the new ethical framework guidance. They have to have regard to this and seek to apply these principles in their delivery and operation of the social care system in the area. The guidance sets out a number of principles and values which are described as a starting point, but they're certainly not an exhaustive list. They're intended to be a useful ethical checklist to enable practitioners to be confident that they are considering the rights and principles and values when seeking to deliver support during the pandemic. And the principles that are set out in the ethical framework guidance are as follows: that practitioners should respond with respect, reasonableness, they should seek to minimise harm, they should be inclusive, accountable, flexible, proportionate, and seek to enhance community within their work. Consideration of these ethical principles does, of course, mean that high-level decision makers and practitioners will in some circumstances need to balance the needs of some against the needs of others, against certain sort of groups within the community and cohorts, or certain individuals, sort of as against other individuals. There is, however, also a backstop that means that councils must consider the very particular needs of an individual and consider the impact on an individual's life were support not to be provided. And that comes in the form of the provision in the Coronavirus Act and in the guidance, which sets out that support must be provided to prevent a breach of an individual's human rights. The relevant human rights for these purposes are the right to life in Article 2 of the European Convention on Human Rights, the right to be free of inhuman and degrading treatment, Article 3, the right to a private and family life set out in Article 8 of the Convention, and the right to freedom from discrimination in Article 14 of the European Convention. Now, it's fair to say that historically it's been very difficult in social care cases to argue effectively that there's been a breach of an individual's human rights, particularly a breach of Article 3, the right to be free of inhuman and degrading treatment. And where arguments have been brought in the past, courts have been reluctant to find that the state has breached an individual's rights, that the state has failed in some way in its obligation to prevent an individual from being free of degrading inhuman and degrading treatment. However, the lockdown in place at the moment, the restrictions placed on individuals' liberties, might change how courts respond to claims brought on an Article 3 basis. Practitioners in the field think that perhaps the courts might be slightly more sympathetic to individuals who are saying that they are being subjected to inhuman and degrading treatment as a result of lack of certain type of care or support being provided in a certain way, because those individuals might be particularly vulnerable during the period of the pandemic, and they may have an absence of support that would normally be there to ensure that their dignity and integrity was upheld. So it'd be interesting to see how the courts do consider those arguments. Article 8, on the other hand, has generally been interpreted quite broadly in the courts, and they've been more willing to find in Article 8 breaches, and we suspect that will continue to be the case during the pandemic. So here, breaches of private and family life really could be interpreted quite broadly. They include, it's important to say, not just relationships with family, marital relationships with children, but they also include wider relationships. So private and family life includes relationships with friends, maintaining wider social connections, maintaining your personal integrity and your personal dignity. It's possible to see that where individuals rely on support for access to the community, for example, that Article 8 arguments could be made if removal of support meant that an individual no longer had that access to the community, no longer had the ability to maintain relationships with their friends and maintain those wider social connections on which they rely. We've seen that the Coronavirus Act changes very significantly adult social care law during the pandemic, in particular by allowing councils to depart from key Care Act duties, such as duties around assessment, making decisions about eligibility for support planning, and actual provision of support itself. But there are some important provisions of adult social care law which remain unchanged. There are key duties under the Care Act that remain unchanged by the Coronavirus Act. And in particular, duties that we looked at earlier, the duty to promote wellbeing remains in force. The duty that councils have to prevent needs for care and support from arising and to delay the development of needs, that duty remains in force. Councils still have a duty to provide information and advice. And in fact, the demand and the need for information, accurate information and advice about adult social care might be heightened at the moment, so that duty is perhaps going to take on an even greater significance in the coming months and years. And the duty to safeguard vulnerable adults that councils have remain in force. However, I do think it's worth noting that although these key duties remain in force, so this is the law by which councils will be bound, it's difficult to see how some of these might be delivered, might be affected in practice if councils do move into the higher levels of easements. For example, if councils move into level 4 of easements and start prioritising certain types of need or certain types of services over others, it's difficult to see how that would be consistent with the general duty of wellbeing, whereby no aspect of an individual's sort of life is more important than other aspects. So there's no hierarchy of aspects of wellbeing under the wellbeing principle set out in the Care Act, but yet councils operating a level 4 easement will be able to prioritise, to sort of pick away at certain needs or certain aspects of an individual's life that they think are more important than others. So I do think it's going to be interesting to see how this law in practice pans out, because I can see that there are going to be tensions between these existing duties and the eased duties that councils have if they move into the higher levels of the easements that they're enabled to do through the Coronavirus Act. There is, however, also law that remains in place that is unaffected by the current by the Coronavirus Act at all, and that is the Equality Act. And this includes a duty that all councils have known as the Public Sector Equality Duty, whereby in the exercise of their public functions, which would include the delivery of adult social care, they must have regard to the need to eliminate unlawful discrimination, harassment, victimisation towards people with protected characteristics, namely those they should eliminate discrimination by virtue of age, disability, gender reassignment, marriage and civil partnership status, pregnancy and maternity status, race, religion or belief, sex and sexual orientation. They remain under a duty under the Public Sector Equality Act to advance equality of opportunity between people who share a protected characteristic and those who do not. So they are in refining the social care systems in their areas at any one time when they're seeking to respond to needs in the area, going to need to be mindful of the need to ensure that equality is advanced between individuals with different types of disability and those who have disabilities as against those who don't. Councils will also need to continue under the Public Sector Equality Duty to try and foster relationships between people who share protected characteristics and those who don't. So they need to ensure that the wider community unity of individuals with illnesses, disabilities, and those who don't have illnesses and disabilities can be maintained. What does all of this mean then for service users and carers in practice? We're going to have a look at some possible scenarios together so that we can try and work through how the new law might apply to different situations. This certainly isn't exhaustive, and obviously each individual's situation will need to be considered on an individual basis on its own merits. But here I'm going to set out some broad principles in some work through scenarios for you. Obviously, the way that individuals, both adults and carers, will be affected by changes to adult social care law is going to depend on the extent to which councils seek to operate the higher levels of easements. If councils remain at lower levels of easements, level 1 where everything's operating as normal, or level 2 where councils are seeking to apply flexibility to the way they carry out their functions, then in practice service users and carers might not feel much of a change in terms of the legal changes to adult social care. However, if councils are operating higher levels of easements, then clearly individuals who would ordinarily access health and social care support and their carers might start to notice a real change in the way that care is being operated in their area. Where social distancing measures mean that individuals aren't getting the help that they normally rely on, and this could be informal help from friends or family, they might be more vulnerable than they ordinarily are. They might have a decline in their health or well-being, which means that they may well be needing support from the council social services for the first time. Equally, there are some adults who might be fairly independent usually, but whose condition is made worse and their independence might decline as a result of the measures that are currently in place at the moment. They might be needing extra help that they wouldn't need normally. Well, in these circumstances, if the councils are operating low-level easements, so if they're at level 1, then the usual Care Act duties apply. So in those situations, we might expect that the council would be doing an assessment, even if the assessment had to be done slightly differently, and might be looking at what support would be needed to meet any eligible needs identified during the course of an assessment. So in those circumstances, the duties of the council would largely correspond to the Care Act. If, however, a council is operating higher level easements, then it might be that a detailed assessment might not be done, but council still, nevertheless, would have to respond to a request for care and support, consider needs, albeit that they might do that in a much more sort of fast and a lighter touch way. More complex needs will still require more consideration. Council still need to consider the wishes and feelings of service users, carers, those who might need support, and they still need to assess what support might be needed to some extent, even if they're operating at higher levels of easement, because, of course, they cannot fail to provide support if it would lead to a breach of human rights. So enough information has got to be gathered and enough analysis needs to take place for a council to reach a stage where they can make a decision about that. There will be adults who usually receive certain types of care and support within their support packages that can't be delivered at the moment. For example, those who access day centres or respite facilities that might be closed, those who are taken out into the community by a personal assistant. At the moment, some of these types of service won't be being provided due to social distancing measures, self-isolation. In these circumstances, councils should be thinking about alternative ways of providing care to meet assessed needs. And if they are operating under the lower levels of easement, then an individual's eligible needs should still be met. So that might mean councils need to think of different ways of providing support, such as providing direct payments to enable a family member to do activities with an individual at home rather than them access the day centre as they ordinarily would. what is important is that under those lower levels of easements, an individual shouldn't be left without the support that they need to meet their needs. At the higher levels of easements, individuals may well find that a review of their support packages in light of the change, namely the removal, the closure of certain services that they usually operate, doesn't take place. The council might not be doing reviews, or might not exercise the power that it has to do a review. And the council might indeed be removing or temporarily stopping or reducing certain types of service altogether. Where this happens and the result is that an individual is left without care support that they ordinarily access, ordinarily rely on, the council should nevertheless be every 2 weeks reviewing the whether it's still the case that that service, that type of support to that individual can't be provided, and the support must be put back in place as soon as possible. In any event, individuals cannot be left without support that would lead to a breach of their human rights. So if an individual's rights would be breached, then support would have to be put in place. There are also adults whose health will have deteriorated during the pandemic itself, and who have had to go into hospital and might need to be discharged from hospital, whether having had COVID-19 or whether as a result of other health complications, illnesses, disabilities. But they may now be needing additional social care support, and that might need to be in a care home or other residential setting. Here, councils should be assessing the needs of individuals to determine what support might be needed. The assessment itself might happen in a different way, but support would need to be put in place to meet any needs that are identified. And I think here the safety of adults already in those placements, as well as those being moved into the placements, would need to be considered by councils. And support planning might well involve consideration of how those who need to be shielded or protected from contracting COVID-19, so those who have been put in a particularly vulnerable groups, should be considered. Councils might not, however, give the same effect to the choices of individuals about preferred accommodation that they would if we weren't in the circumstances where we're in a health pandemic. So those duties relating to choice might have been removed, and that means that councils might not give an individual a choice as to where they're going to be placed once they're discharged from hospital. There is specific guidance that could be referred to here as well. So it's worth saying there's hospital discharge guidance that's been produced by the NHS, and there's also discharge to care home guidance that's being produced, to which councils need to have regard. Some individuals who might display challenging behaviour or might have sort of difficult behavioural problems associated to their illness or their disabilities might be starting to display increasingly challenging or antisocial behaviour as a result of lockdown or socialisation measures, or the stresses of the pandemic itself. And they may be placing themselves at a risk of losing their homes if they are tenants in properties. Now, although evictions have temporarily been halted at the time this webinar was recorded, landlords may nevertheless be gathering evidence as a result of sort of challenging behaviour incidents that might then be used to for them to seek eviction later on. Here I would say that those individuals might have a need for care and support services from the council to prevent further needs arising, i.e. to prevent them becoming at risk of losing their homes, or to prevent a significant decline in their health or well-being. The duty that council has to prevent deterioration and further needs remains unchanged. So that key duty that local authorities have remains unchanged. But even under the the changes, if the councils are operating easements at lower levels, usual duties to assess apply. If not, councils still have to consider needs to be able to make a decision about whether human rights would be breached. So if the council is operating the higher levels of easement, they will still need to look at whether there might, if support is not provided, be a breach of Article 8, for example, which would be the private and family life includes an individual's home, and loss of a home would clearly be a very significant impact for an individual. There are individuals who might be particularly vulnerable to abuse during the pandemic. Often individuals who have illnesses and disabilities have many eyes on them, have much opportunity for individuals to see and check how they are by going to day centres, recreational activities, clubs, etc. And at the moment, a lot of those things aren't happening. It might be that those individuals are going to be at increased risk as a result, and the tensions within homes and the demands of their caring for them, for example, might create sort of difficulties that could lead to them being abused. The safeguarding duties local authorities have remain unchanged. So if individuals coming into contact with them become aware of those individuals being at potential risk of harm, then the council can be contacted in the usual way, and a safeguarding referral can be flagged up. For carers, some people might be new to caring and might have become carers because a relative or family member has become ill during the pandemic, is classed as vulnerable, so might need to be supported at home, or unable to access support they usually rely on. Or an individual who's already providing care might find that their caring role has increased substantially because they don't have any respite from care that they would ordinarily have if the person they care for goes to a respite facility, a day centre, for example, during the day. In these circumstances, the council may have duties to provide support to sustain the caring role. And if low levels of easement are operating, the council can be asked to assess the carer's needs in the usual way. If not, the council nevertheless has to look, if the higher levels of easement are operating, nevertheless has to look at whether the carer's human rights or the person that they care for's human rights would be breached if support was not provided, either to the carer directly or to the individual who requires care. So we can see that the situation for individuals and their carers is largely going to depend on what stage of easements the councils are operating at any one time, but also it's really going to matter what their personal circumstances are and what the impact for them would be of not receiving support. If there is a dispute about what individuals feel that they need from the local authority and what the local authority is saying or doing in response, then there are two ways that dispute can potentially be resolved. The first is through the local authority's complaints procedure, which is still operating during the pandemic. The procedure involves an individual making a complaint, the council seeking to resolve it internally. If that can't be resolved internally, then the complaint can be progressed to the local government ombudsman. However, I do think a word of caution is needed here, and that is that some councils are sort of stalling or sort of putting on hold consideration of complaints at the moment because of the pandemic and because of their resources being needed elsewhere, and that means that it might take a very long time for a complaint to be resolved. If the complaint is being made about a need which is urgent or a crisis situation that's unfolding within a family, then resort to the complaints procedure here might not actually be effective in resolving the issue. The other option open to individuals is judicial review, which is the process by which the administrative court is asked to consider whether a council, in the exercise of its public function, has acted lawfully. And by that we mean whether the council has complied with the law correctly, acted rationally and acted fairly. It's not a decision about whether a council has made the right decision on merits, about what kind of support to provide to an individual or whether or not an individual qualifies for support at all, but rather a decision about whether what the council has done falls within the law, falls within what the council is able to do from a legal perspective. Judicial review similarly has a number of stages. The first is that a letter is sent by a health and social care solicitor to the council setting out why it's alleged that the council has acted unlawfully. The council is then given the opportunity to respond to that, and that often resolves the issue. If that doesn't resolve the issue, the next stage is for an individual to issue a claim through a solicitor at the administrative court, and a judge then considers if the claim might succeed, and if so, gives the claim what's called permission to be heard. So the judge is saying that the case has enough merit on the face of it to go to a full hearing. And then the final stage will be for a judge to actually consider the case in full, to consider whether a council has in fact acted lawfully in the exercise of its public functions, delivery of health and social care here. Usually the times for judicial review are also slow, because the administrative court a large cases to consider. However, where there is an urgent or crisis situation, notification can be made for asking for the case to be done more quickly, and in relief can be requested, and that means that you can ask a judge to provide a certain kind of support, a certain remedy, whilst the case is waiting to be heard. I hope that's been a helpful summary of the pre-existing law, the changes to the law that the Coronavirus Act has introduced, the parts of the law that remain the same, and how that might be felt by service users and carers in different situations. I think that this is going to be a time of great uncertainty, and I do think there's going to be a constantly evolving and changing pattern and practice within council areas. I suspect that some councils will move in and out of different levels of easement fairly regularly, albeit that they will need to go through those correct processes in terms of making decisions about which level of easement they need to operate at, that we've looked at as part of the webinar. To some extent, that's the point of these emergency measures. They are to enable councils to respond effectively to changing situation in their area at any one time. But I think we're certainly going to see a yo-yoing in and out of easements. Something else that I think we're going to see is an increased need for councils to really be able to demonstrate thorough reasoning and analysis in the decisions that they take, because a lot of individuals, vulnerable individuals, are going to be affected by those decisions, and the decisions of council will need to stand up to scrutiny. So we're going to be looking a lot more carefully at the way local authority decisions are made, both at a high level basis, the decisions of the council to move in and out of different levels of easement, and how those easements are then applied to individual circumstances on a case-by-case basis by social care practitioners. In my view, a key here is going to be the guidance, because it's very helpful. There's a lot of it, and I think in terms of helping individuals access the help and support that they need, there are some really useful sections of guidance that have been published, and I think reference to those will be increasingly important in the coming months. I also think there's going to be greater scope for use of human rights arguments than there has been previously, because individuals are going to be made more vulnerable by the current situation, by the restrictions on their liberties and freedoms, and as a result, the state's obligations to prevent and breach their human rights, I think, are going to be heightened, and I think the court will be more willing to examine whether councils are complying with those obligations. And finally, a bit of a grim prediction, but I think that councils are going to be, at some stage, we expect, moving into prioritisation of types of service or types of need. And I think that although the Care Act will be reinstated once the Coronavirus Act lapses, so either at the end of the 2-year period or before or after, if it's extended or the timescale is reduced. But I think it's going to be difficult for councils to move away from a practice of prioritising certain types of service or certain types of need, and considering that some needs are more important than others, or some types of service are more important than others. So I think it's really important that anybody working in the field of social welfare, working for disability charities, or organisations working as advocates, keep a focus on well-being, keep a focus on the Care Act as it was before the pandemic, to encourage councils to move back to that position as swiftly as possible. Central England Law Centre are a community law centre, and we're here to help vulnerable individuals during the pandemic, and we're trying to do that in a number of ways. This is one of a number of webinars that we're hoping to produce about the health and social care law and changes to that law. There will be a further webinar on the changes to the law relating to disabled children that will follow, and so please do look out for that. We're also going to be running COVID question clinics, so if you have a question as a practitioner, as an advocate, as an individual working in the field of social welfare, then please do join us for the COVID question clinics. Contact us and we can let you know when they're running. But essentially, you're able just to call into to a meeting, and if you've got questions, raise them with us, and we'll do our very best to answer them or to steer in the right direction. We're also providing information, materials, leaflets, as much as we can. So if there's something specific that you need information about, or your organisation really needs information about in the field of health and social care, do get in touch with us, and we will try to provide information that's useful to you. Obviously, as a law centre, the other thing that we can do is to provide legal advice, both to service users and carers. So if you have clients who you think would benefit from legal advice in relation to their situation, do get in touch with us, and we can try and help them by providing them with advice. And finally, to say that we have set up a service help and guidance information pack, which is currently operating in Coventry and provides a lot of information about changes to different areas of social welfare law as well as social care, and provides information about local services that are directed, that are currently operating, directed at helping with social welfare problems. We are hoping to expand that provision into Birmingham also, but do get in touch with us if you'd like to receive further information about that. I can be contacted by email at emma.austin@centralenglandlc.org.uk. Do get in touch if we can be of help to you, your organisation, or the individuals that you're working with. I hope that you found this useful. Please do contact us if you've got any questions or there's anything else that you'd like us to cover. Thank you.